Big question here for the jury to decide. Was it an act of self-defense or not? A jury in Florida is going to decide a case that sparked national attention. Michael Drejka claims he feared for his life when he shot Markeis McGlockton in the parking lot of a Clearwater convenience store. This was in July of 2018. The argument was apparently over a parking spot, but the trial could hinge on 11 seconds of grainy surveillance footage. Defense attorney and former prosecutor David Bruno joins me now. Jury selection, David, gets underway tomorrow. So what is the juror's job in this case? This is not stand your ground, because I was reading articles about the stand your ground defense, which isn't one, right? It could be used in a pretrial hearing.
That's correct. Stand your ground relates to the concept that somebody does not have to retreat, and it gives the defendant a right to a pretrial hearing in front of a judge where the judge makes the decision if there's immunity. However, this defendant chose not to have that hearing, and this is going to be an issue for the jury whether or not he was justified in using self-defense using deadly force.
That is Michael Drejka, the mugshot that we're looking at as you speak here. The surveillance footage that we looked at that can be used, again, 11 seconds of that. How incriminating will that be? Because you see what happens, David, but can you really understand a person's fear, and what does a jury have to decide there?
Well, the legal standard that the jury is going to have to deliberate over is whether or not he reasonably believed that force was necessary to prevent imminent great bodily harm or death. Now, the key to that is reasonable, because it's not just the defendant's subjective mental intent, whether he feared. It's really objective and looking at the circumstances. Here in this video, the victim is actually moving away from the defendant at the time of the shooting when the defendant said in his statement that he was coming running at him. Huge difference between this case and the Zimmerman case. Let's not forget, in the Zimmerman case, there was not a video. Mark did a great job disputing facts and whether or not Zimmerman was getting hit, whether or not the back of his head was hitting the cement at the time he was being attacked. Not a dispute here. Here we have the video, and like you said, it's going to be slowed down. The 11 seconds is going to be slowed down frame by frame for this jury. And when they have to determine whether or not it was reasonable objectively, they're going to see that the victim was moving away from the defendant at the time of the shooting and not towards. I think that is the reason this defendant will be convicted, and the reason I see this differently from the Zimmerman case.
Yeah, in the Zimmerman case, he was a self-proclaimed neighborhood watch guy, Trayvon Martin. We all remember that case, just holding Skittles, nothing else. This case, he said he feared for his life. The jury has to, and you mentioned the key word here, reasonable. Was he in fear of his life? It has to be reasonable, and we shall see what the jury does decide as they're being selected this week. David, thank you so much.
Pleasure, Susan.